You need to stop what you're doing right now. I'm not exaggerating. I'm not doing this for clicks. What I'm about to tell you in the next few minutes could literally be the difference between you walking free tonight and you sitting in a holding cell wondering what happened to your life. Because right now in April of 2026, there are 7 specific firearms that millions of Americans own, store in their homes, take to the range, and sleep next to for protection that are either already illegal or on the razor's edge of becoming illegal in your state. And the most dangerous part, most of the people who own these guns have absolutely no idea. I've been covering Second Amendment law for years. I've watched rulings come and go. I've seen politicians grandstand and courts push back. But what is happening right now in this specific moment in April of 2026 is different. This isn't the usual political noise. This is a legal earthquake, and the aftershocks are landing directly on your gun safe. The Supreme Court is in the middle of multiple major gun cases simultaneously. State legislatures are passing sweeping new restrictions faster than any single news outlet can track. And real gun owners, people who have never broken a law in their lives, are waking up to find that the firearm they bought legally, cleaned religiously, and stored responsibly is now a felony waiting to happen. Before we get into the 7 guns, I need you to do one thing. If you are serious about protecting your constitutional rights, subscribe to this channel right now, because what's happening in the courts this month alone is moving faster than most people can follow. And when a major ruling drops, you need to hear about it immediately, not 3 weeks later when it's too late to do anything about it. Hit subscribe, turn on notifications, and then stay with me, because every single word of what I'm about to say matters. Let me give you the full picture of what's going on at the Supreme Court right now, because you can't understand why these 7 guns are in danger without understanding the battlefield they're sitting on. This April, the Supreme Court was hearing arguments in a case called United States versus Hamani. At the center of this case is a question that sounds simple, but is actually legally explosive. Can the federal government strip someone of their right to own a gun simply because they use marijuana, even in a state where marijuana is completely legal? When you listen to the justices' questions during oral arguments, the skepticism toward the government's position was hard to miss. Multiple justices pushed back hard on the idea that marijuana use alone, without any history of violence or danger, is enough to permanently eliminate a constitutional right that leans toward expanding gun rights for a significant portion of the population. But on that exact same day, the Supreme Court refused to block a completely different gun ruling out of Maryland. That ruling allows the state to permanently confiscate firearms from anyone sentenced to more than 2 years in prison. 2 cases, same day, opposite results. One potentially loosening restrictions, one tightening them. And that right there tells you everything you need to know about the legal environment we are living in right now. The courts are not moving in a single clean direction. They are pulling and pushing at the same time. And the uncertainty that creates is exactly what allows these state-level bans to keep operating, keep being enforced, and keep destroying the lives of otherwise law-abiding gun owners. Now, here's the foundation you need to understand before we get to the list. Back in 2022, the Supreme Court handed down what should have been a game-changing ruling in New York State Rifle and Pistol Association versus Bruin 623, with the majority establishing that any modern gun law must be evaluated against America's historical tradition of firearm regulation. Simply put, if a restriction on guns has no meaningful parallel in the founding era of this country, it likely cannot survive constitutional scrutiny. That ruling sent shockwaves through state legislatures, and in many courts it has genuinely worked. Judges have used the Bruin standard to strike down laws that never would have fallen before 2022. But here's what the gun control lobby did in response. They didn't retreat. They redoubled. They argued that certain weapons are so uniquely dangerous that they fall outside constitutional protection entirely, regardless of how common they are or how long law-abiding citizens have owned them. And they kept passing laws, kept defending those laws in courts that sometimes agreed with them, and kept enforcing those bans while the litigation dragged on for years. So right now, today in April of 2026, you have this bizarre situation where a firearm might be constitutionally protected under the Bruin framework and still be actively banned in your state because the case challenging that ban hasn't made it to the right court yet. That is the world we are living in, and that is exactly why these 7 guns are so dangerous to own without knowing exactly where you stand legally. I want you to think about something before I break down the list. Do you believe the states pushing these bans should be stopped by the federal courts? Drop that in the comments right now. Tell me what state you're in and what you think about what's happening. And while you're down there, hit that like button. It takes 2 seconds, and it tells the algorithm that this information needs to reach more gun owners who might not even know they're in legal jeopardy right now. Let's get into the 7 guns, and I want to be clear about something. Like, these are not hypothetical. These are not future predictions dressed up as current news. These are firearms that are either already banned, newly restricted, or sitting under laws that took effect within the last several months in states where real people are living right now with these guns in their homes. The first firearm is the one that started this whole modern battle, and that's the AR-15, and every rifle that shares its operating platform. The AR-15 is the most popular rifle in American history. There are somewhere between 20 and 25 million of them in civilian hands right now across this country. It is by any objective standard the definition of a commonly owned firearm, and yet it is banned from sale, transfer, and manufacture in at least 10 states as of right now in April 2026. California has banned it. Illinois banned it through the Protect Illinois Communities Act. New York, New Jersey, Maryland, Connecticut, Hawaii, Massachusetts, and Delaware all have active bans, and Rhode Island just added itself to that list with a new law signed into effect that kicks in on July 1st of 2026. What makes these bans particularly devastating for gun owners isn't just, that you can't buy a new one. It's what these laws say about the ones you already own. In Illinois, for example, you were supposed to register your pre-ban AR-15 with the state. If you missed that window or didn't know about it, your grandfathered status is legally questionable. In California, the rules about what you can do with a registered assault weapon, who can touch it, how it can be stored, what happens when you die, and want to leave it to your kids are so complicated that even experienced attorneys get lost in the details. The AR-15 ban isn't just about stopping new sales. It's about slowly making ownership itself so complicated and legally treacherous that people give up voluntarily. And it's working on people who don't stay informed. The second firearm is the AK-style rifle. We're talking about the semi-automatic civilian versions of the AK-47 and AK-74 pattern rifles. These are not automatic weapons. They fire 1 round per trigger pull, exactly like any other semi-automatic rifle, but they are banned in the same states that ban the AR-15, and sometimes they're banned even more specifically. California's Assault Weapons Control Act names AK pattern rifles directly. New Jersey has a name model list that specifically calls out AK variants. New York covers them through what's called the feature test, and this is where it gets technically complicated in a way that traps gun owners who think they're being careful. The feature test works like this. If your semi-automatic rifle accepts a detachable magazine, and it also has any single one of a list of prohibited features, including a pistol grip, a folding or telescoping stock, a thumbhole stock, a grenade or flare launcher, a flash suppressor, or a forward pistol grip, then it is legally classified as an assault weapon, and it is banned. You don't have to be on a named list. You don't have to look like a military weapon. You just have to hit that one feature trigger and you have crossed the line. Now, this is how gun owners who think they've been careful end up in violation. They changed one part, they added one accessory, they modified one feature, and without realizing it, they turned a legal rifle into a felony. The third firearm on this list is one that shocks people when they hear it, because most people assume handguns are safer ground legally. The restricted semi-automatic pistol. New Jersey specifically bans semi-automatic pistols that weigh more than 50 ounces when unloaded. Think about what that covers. Certain competition pistols, certain full-size duty guns with heavy frames, certain handguns that were specifically designed to reduce felt recoil through added weight are now banned by the scale in New Jersey. California and New York take a different approach using feature-based rules that can reclassify a standard semi-automatic handgun into a prohibited weapon if it has certain modifications, stock configurations, or accessories. So if you've been customizing your carry gun, adding a stabilizing brace, changing out a grip, installing a certain kind of magazine release, you may have unknowingly walked your legal pistol across a line that turns it into a banned weapon. Nobody warns you at the gun counter when you buy those parts. You are expected to know. The fourth firearm is the .50 caliber rifle. Illinois, through the Protect Illinois Communities Act, doesn't just ban assault-style rifles. It bans .50 caliber rifles and even .50 caliber cartridges themselves. California has restricted .50 BMG rifles for years. These are precision long-range platforms used primarily by competitive shooters and collectors. They are expensive, they are specialized, and they are genuinely rare compared to something like an AR-15, but they're on the list. And the reason that matters isn't about how many people own them. It's about what the inclusion of these rifles tells us about the direction of these laws. When legislators start banning cartridges, not just guns, not just magazines, but the ammunition itself, they are signaling something. They are showing you how far the net is willing to stretch. The .50 caliber ban isn't the end of anything. It's a preview. I'm going to get to guns 5, 6, and 7 in just a moment, and number 7 is going to genuinely catch you off guard because it involves a type of firearm that almost nobody expected to be politically targeted. But first, I need to ask you something. Are your notifications turned on for this channel? Because when courts issue rulings on any of these bans, and rulings are coming, possibly within weeks, you need to know immediately. Turn notifications on right now. The update you miss could be the one that changes everything about how you legally own your guns. The fifth firearm is the semi-automatic shotgun with prohibited features. This one flies under the radar more than almost anything else on this list because most people think of shotguns as the safe choice, the home defense gun that nobody's going to come after. They're wrong. Delaware's assault weapons law specifically covers semi-automatic shotguns. New York's SAFE Act reaches them through the feature test. California has restricted certain configurations for years, and the pattern is the same as with rifles. Detachable magazine plus any one prohibited feature equals a banned weapon. So if you've got a tactical semi-auto shotgun that you bought specifically for home defense, maybe it's got a pistol grip, maybe it's got a folding stock, maybe you added a magazine extension, you need to check right now whether the configuration it's currently in is legal in your state, because the gun that's sitting in your closet tonight might be legal in the state you bought it in and illegal in the state you live in, and that's a reality a lot of people are not prepared for. The sixth firearm is the AR pistol with a stabilizing brace, and this one has a history that's almost impossible to keep track of unless you've been watching it closely. The ATF under the previous administration tried to classify pistol stabilizing braces as rifle stocks, which would have instantly turned millions of AR pistols into short-barreled rifles, which are subject to the National Firearms Act and require a federal tax stamp and registration. That rule got tied up in litigation and ultimately failed to survive judicial scrutiny in most circuits. So federally, you might think you're clear. But at the state level, the story is completely different. California, New York, New Jersey, and several other states had already moved to close what they called the pistol brace loophole, meaning they updated their state definitions of assault weapons to capture AR pistols regardless of what the ATF was doing federally. In those states, your AR pistol with a brace is still a banned weapon, not because of federal classification, but because the underlying firearm platform triggers the state's assault weapon definition on its own. The brace issue gave a lot of people false confidence. They followed the federal situation closely, saw the ATF rule fail in court, and assumed they were fine. But if they live in a banned state, they were never fined because the state law never cared about the brace in the first place. The seventh firearm is the one that's going to stop you cold, and it's not the AR-15, it's not the AK, it's the revolving shotgun. Rhode Island's new assault weapons law, the one that was signed and takes effect on July 1st of 2026, doesn't just expand the list of banned semi-automatic rifles. It specifically and explicitly names revolving shotguns as prohibited firearms. A revolving shotgun, that is not a weapon anyone was writing op-eds about. That is not a firearm that shows up in crime statistics in any significant way. It is a niche platform with a small but passionate following among collectors and certain competitive shooters, and yet there it is written directly into Rhode Island's new law named specific banned. And why does that matter beyond the small number of people who actually own one? Because it tells you exactly where this is going. These new laws are no longer just targeting the guns that get airtime on cable news. They are widening the net, deliberately stretching the definitions and reaching into corners of the firearms world that nobody expected to be touched. The revolving shotgun ban is a message. It's telling you that if they're going after this, nothing is off the table. Now, let me tell you what this actually means for your life, not in theory, but in the real world scenarios that are happening to real gun owners across this country right now. Picture this. You just accepted a job offer in New Jersey. Great opportunity, better pay. You're excited. You pack up everything, including the AR-15 you've owned for 8 years, never fired at anything except paper targets. Always stored safely, always handled responsibly. You didn't think twice about it because you've been a law-abiding gun owner your entire adult life. The moment that truck crossed the state line into New Jersey, you became a felon. Not because you did anything wrong, not because you're dangerous, but because a law exists in that state that reclassifies a legal firearm as a criminal offense. And nobody at the moving company, nobody at your new job, nobody at your real estate closing told you. That scenario is not hypothetical. It is happening to real people right now, and the consequences are life-altering. Or consider this. You've lived in Illinois your whole life. You bought your AR-15 before the Protect Illinois Communities Act passed. You've heard that you're grandfathered in, and you've taken some comfort in that. But what the grandfather clause actually says and what it actually protects is far more limited than most people realize. The registration requirements were complicated. The deadlines were confusing. The rules about who can handle the firearm, how it can be transferred, what happens if you temporarily move out of state and come back are full of landmines that attorneys are still sorting out. Grandfather doesn't mean free. It means conditionally tolerated for now under rules that can and do change. And there's one more scenario that catches people in free states completely off guard. You're driving from Virginia to Pennsylvania with your rifle in the trunk, locked, unloaded, cased, in full compliance with federal transportation guidelines under the Firearm Owners Protection Act. Your route takes you through Maryland, and somewhere along the way you stop. You pull off the highway, you get a hotel room because it's late and you're tired. That stop, that single overnight stay, may have cost you the federal protection that FOPA provides for transit through states where your firearm is otherwise banned, because that protection only applies when you are traveling directly without meaningful interruption from legal state to a legal state. And Maryland State Police have made arrests in exactly these kinds of situations. The law is not forgiving when you don't know it. There are 3 myths spreading fast right now that I have to kill before they get someone put in handcuffs. The first myth is that the Bruen ruling already fixed all of this. It didn't. Bruen established a new constitutional framework, but it did not automatically invalidate every existing gun ban in America. Each law has to be challenged individually. Each challenge has to survive appeals. Each case has to potentially make its way to the Supreme Court before a specific ban is actually struck down. Bruen is the new rule book, but the referee hasn't walked over to every play yet. The bans are still active. Law enforcement is still enforcing them today. The second myth is that if a gun store sells something to you, it must be legal in your state. This is dangerously wrong, and it has cost people their freedom. Some dealers make mistakes. Some are located near state lines and primarily serve customers from other states. Some are selling a firearm that is legal where they are, but illegal where you live. The sale itself provides you zero legal protection. You are responsible for knowing your state's laws, and the gun store sold it to me is not a defense that holds up in court. The third myth is that these laws are aimed at criminals and law-abiding owners have nothing to worry about. That is precisely backwards. Criminals don't register their weapons. Criminals don't follow feature test rules. Criminals don't comply with magazine capacity limits. These laws land hardest on the people who have always done everything right, who bought legally, who stored carefully, who never gave anyone a reason to question their ownership. The law takes a firearm you have been handling responsibly for years and reclassifies it with a stroke of a pen. And then it expects you to know that happened and comply immediately. That is the reality of what these bans do. And the person most at risk is not the career criminal. It is you. Here is where the legal tide might actually be turning. And I want to give you the honest picture because you deserve accuracy, not just outrage. A federal court just struck down the Washington, D.C. magazine ban in April of 2026, ruling that commonly owned magazines are protected by the Second Amendment under the Bruin Standard. That is a genuine legal win. The Illinois assault weapons ban is being challenged in the Seventh Circuit Court of Appeals right now with connections to cases that gun rights groups are positioning for Supreme Court review. If the Supreme Court takes up a direct assault weapons ban case, we could be looking at the most significant Second Amendment ruling since Bruin itself, but that case hasn't been accepted. That ruling hasn't come down, and until it does, every one of those 10 state bans remains in effect and enforceable. You cannot bet your freedom on a legal outcome that hasn't happened yet. You have to live under the law as it exists today. Here's what you need to walk away from this knowing. If you own any of the 7 firearms we covered today, the AR-15 and its variants, the AK-style rifle, the restricted semi-automatic pistol, the 50 caliber rifle, the feature-prohibited semi-automatic shotgun, the AR pistol in banned states, the firearm paired with a high-capacity magazine, or the revolving shotgun in Rhode Island, you need to know exactly what your state says about it right now, not what it said 2 years ago, not what you've heard from a friend who heard from another friend. What the actual law says today in your specific state about your specific firearm configuration. Your ignorance of the law will not protect you. It never has and it never will. The Second Amendment was written to be permanent. It was written to protect the individual right to keep and bear arms from exactly the kind of incremental government overreach we're watching unfold right now. But rights are not self-enforcing. They require people who understand them, who stay informed about threats to them, and who refuse to surrender them through carelessness or complacency. That is why this channel exists. That is why this video exists. And that is why every single update we put out on this topic matters. The fight for your Second Amendment rights doesn't end in a courtroom or legislature. It continues in every conversation, every election, every informed decision made by a gun owner who knows what they're talking about. Thanks for watching.